or you don't know him, you have not heard him speak before. He is a longtime resident of Golden Valley and has been an attorney for more than 40 years. He ran his own firm for 35 of those years and is currently with the law firm of Meyer Njus Tanick. A graduate of the University of Minnesota School of Journalism and Stanford Law School, Marshall has won numerous awards over the years. He's also a prolific writer, and you may have seen one of his frequent op-ed pieces in the Star Tribune or in the local Sun Post paper. And Marshall is here today to talk to us about major rulings of the U.S. Supreme Court for the past year and what lies ahead. So please welcome Marshall Tanick.
You want to use the arrows to get them back to one?
Yeah. Okay, there we go. Okay, thank you. Thank you very much, Peggy, and thank you all for having me here again. I'll just start the happy bucks. I appreciate you putting that at the end here, so give me a little bit of time. I'll do what the often ask the judges. How much time do I have here? When do you want me to finish here?
Quarter after, 1:15.
I got 25 minutes. Good. I give a version of this presentation to lawyer groups and others, and I'm giving one. If you this Thursday, I'm giving this a version of this presentation to the Dakota County Bar Association, Dakota County Lawyers in Dakota County, and if you're interested, you can go on their website and check it out. That's 90 minutes. So this is an abbreviated version of that. So I'll skip through. If you're wondering why my wife, that's my wife Kathy Gorley. She's a lawyer with Testifying. If you wonder what she's doing there, she's participating with me in the next presentation. So we got her picture on there, but she's not here. A couple of quick happy bucks. Julie, I was going to play Happy Bucks Shaper Park. I mentioned that it's a great place. My grandson's coming in town next week, and he'll be there. And so there's my happy buck. My grandson's name is Solomon. Shep's oldest son is Solomon. He played on our basketball team, terrific point guard. He's hoping to go to medical school. I hope my son just recently completed medical school, so there's another happy buck for Solomon number 2, or Solomon number 1, I guess. All right. This is a timely, I think this is a timely presentation. It's about the Supreme Court. I call it 9 by 9. There's 9 members of the Supreme Court, and I'm going to summarize 9 of their decisions. Not all of them. I'm going to miss a few, overlook a few. I can't get them all in the time period. But I'm talking about 9 different cases decided by the Supreme Court during its last term, which concluded sort of at the end of June. It's still kind of going on. But the Supreme Court traditionally has met from the first week in October. First Monday in October is when the Supreme Court has met. Begun its sessions for some 200 years. And it starts in October, ends at the end of June, and then the judges take the summer off and go on these luxury trips paid by other people. But now they don't do that anymore. I mean, this year, as we've seen, the court's in session seemingly all the time with these emergency decisions, and every day it seems we're reading about the Supreme Court did this and the Supreme Court did that. So this idea of this 9-month time period is kind of obliterated, at least for the current time period. So it's kind of a continuous time period. But Monday, October 5th is when the Supreme Court starts up its official calendar. These are the cases I'm going to talk about. I probably won't get to all of them, but I did pass out a sheet there that you can take notes on, and that's just to kind of follow along with me. Won't get to all these, but I'll do as many as I can. A couple of my, few overview cases. This is the 50,000-foot overview for me. This past term, there were no big blockbuster cases. There were a lot of important cases. In fact, all the cases that we talk about are important in different ways, but there were no cases that just grabbed the nation's attention, like the Dobbs case, overruling Roe versus Wade a couple of years ago. And each year there seems to be one case that's really a marquee blockbuster case. Not so much this year, except maybe for the national injunctions case, which I'll talk about in a few minutes. The court still remains sharply divided. A lot of 6-3 votes. The so-called conservatives on one side, the so-called liberals on the other side. A lot of 6-3 votes. Many of the major cases are 6-3, although we'll see there were some unanimous decisions too. But that's been an issue for some period of time. Some thoughts about which judges are moving in what direction, but as a whole, the Supreme Court, as you know, is moving to the right, and it's moving further and further to the right. Some commentators have commented that this year's version of the court was the most, quote, conservative version since 1905, and you you gotta go back a long way to find as many, quote, conservative decisions. And those terms are kind of used loosely, but they generally mean decisions that are, restrictive of certain rights, more pro-business decisions, decisions that are supportive of the current administration. That's what they mean by, quote, conservative, for better or worse. Because of this split, this 6-3 split, which is so prevalent in the big cases, it's fairly easy to predict the outcome if you're someone who really follows this like I do. In every one of these cases I'm going to talk about, I predicted the result except one. And it's not because I'm that smart, but because it's such an ideological split. When you see the case comes up to the Supreme Court, you look at the issues, and sometimes even if you listen to the oral argument, which I do, you have a pretty good idea who's going to win. And I'm able to predict, I was able to predict the outcome of every case except one. I'll tell you which one that is later, because I'm very good at predicting. I'm the guy who predicted the Vikings by 2 touchdowns on Sunday. Last Sunday, I was there too. This shadow docket's a big deal too. You probably have heard that term, shadow docket. What's happening, and it's happening this term, this year, is the Supreme Court, rather than going through the usual process of briefing and arguing cases and having hearings, and the court deliberating and issuing a written decision with reasoning and dissents and concurrences, they're hearing these cases on emergency bases. By these cases, I mean the cases involving the Trump administration. There have been 252 as of before yesterday. I didn't check yesterday's docket. 252, I'll repeat that. Not before the Supreme Court, but total. 252 lawsuits have been started since January 20th. It's actually January 21st. They didn't start until January 21st. They didn't do anything on January 20th. Since January 21st of this year, there have been 252 lawsuits challenging various aspects of the Trump administration, policies, protocols, ranging from that whole gamut from immigration to layoffs to DOJ to military service, military in cities, and all these different issues. 252 lawsuits, about one a day. And not all, about 20 of them have reached the Supreme Court. Ordinarily, it would take about 3 years for a case to reach the Supreme Court. What the court is doing now is having this so-called shadow docket. They're having these emergency hearings. They're hearing the case in 2 or 3 days. And almost, there have been 20 of them, I think, 20 of them, 19 of the 20 have favored the administration. A lot of the lower court decisions that the trial court and appellate court in the federal system have been accepted the challenges to the Trump administration. They ruled in favor of the challenges in many of those cases. Most of those decisions have been made by judges appointed either by Clinton, a lot of Obama judges and some Biden judges. Almost all those cases, not almost all, but about 70% of them have gone against the Trump administration. But the Trump administration has taken 20 of them up to the Supreme Court and they've won 19. These have been turned around in 1 or 2 days, sometimes 3 days. And the decisions have been made, the rulings have been made with no written decisions and no named no named author. They've just been one-page decisions saying Trump wins, reversal decision. There've been no reasoning. It's kind of like going to a football game, going into the stadium and seeing the final score on the board there without seeing the game. They're not giving any reasons for these decisions. There's a lot of reasons why they're not giving reasons, but the reality is, and the judges, the lower court judges are quite upset about this. Some of you may have heard last week in an unprecedented move, 12 lower court judges, some Republicans, some conservatives, some liberals, 12 lower court judges anonymously wrote a letter to the New York Times saying, hey, Supreme Court, you're really messing things up here. We don't know what your rulings are. We know what your rulings are, but we don't know your reasons, so we don't know how to apply this. We don't know what the reasons for these decisions are, so we don't know what to do when a case comes before us. And there's a lot of concern about that because the court is not giving reasons. It's giving results, but not reasons. And that's happening in many of these cases. And there's some other truisms here that too I don't have time to get into, but that's kind of my overview take. Now let's get into some of these cases here. Oops. This gonna work for me, or do I have to use the buttons here? No.
Try the down arrow.
Down arrow.
It's got to
Well, not
click
there.
out now.
Next.
Hit escape.
Yeah, let's go.
What do I push down?
ESC. What? The ESC button, top left.
I don't know what he is. This is my machine. There we go, okay. I can't see it on now. All right, here we go. First case I'm talking about is a Minnesota case. This year, the Supreme Court had 2 Minnesota cases, 2 Some years it has more. 3 years ago, it had 5 cases from Minnesota. Supreme Court decided 60 cases this year, 60. When I was in law school, more than 40 years ago, as Peggy generously pointed out, graciously pointed out, the Supreme Court heard about 175, decided 175 cases a year, with written decisions too. 175. Starting in the 1980s, 90s, and then the 2000s, it reduces workload, not workload, but it reduces caseload down to 100, then to 90, then 80, now it's stabilized at 60. Last year there was 62. 2 years ago there was 62. This year there was 61. So they're deciding about 60 cases with written decisions, apart from these shadow decisions. Okay, so there's not a lot. There's 8,000 appeals are taken to the Supreme Court every year, about 8,000. It's a pretty stable number. The court is now hearing 60 out of 8,000 cases that come to it. What's the Julie? What's the percentage on that? Do some numbers for me here.
I don't have my calculator up, I would have no
Well, I'll tell you, it's
idea.
less than 1%. I did my homework on that. Okay, but they're taking the cases they want to take. This was a Minnesota case. It involved pretty nearby Osseo School District. It involved a disabled student under federal law. Students who have disabilities, most of them are learning disabilities, some with physical disabilities, disabled students, mainly learning disabilities, but other disabilities. Public school districts, taxpayer-funded school districts, are required to give specialized services to those students and give them accommodations. That's a federal law. This case involved a student, a middle school student. She was an 8th grader in Osseo who had epilepsy. And because her epileptic conditions involved, in the morning she just couldn't get up. She had to sleep late and couldn't concentrate. She really wasn't able to go to school in the mornings. Her parents asked the Osseo School District, which is pretty big, to accommodate her by allowing her to come to class late, generally to start class at noon rather than 8 o'clock, and to stay late and go through 4 or 5 o'clock in the afternoon so she'd get her day of schooling, with a teacher assigned to her to work after hours. The school district said, well, that's too bad, we feel very bad for your daughter, but we can't do that. We have to have security here, we have to clean the building up after hours, and we can't have a teacher here because they have to pay him overtime and the union won't let us do that. So they said, no, we can't do that. So they turned down the request for a special accommodation for the student. This parent sued in 2 lower courts, one here in Minneapolis, federal court in Minneapolis, and the appellate court in St. Louis, the 8th Circuit Court of Appeals, both ruled in favor of the school district. They said that the school district does not have to give these specialized services unless you can prove that the school district acted in bad faith. Bad faith is a legal concept meaning real nasty stuff. They said, parents, unless you can prove that the school district was venal and nasty, rather than making a business decision, you lose, and they did lose. Reached the Supreme Court, and the Supreme Court unanimously overruled that. Unanimous decision. Chief Justice Roberts wrote the decision, and they reversed it and said, no, that's too high a standard. You can't require parents to show that the school district was venal in order to give your child special services. All you have to show to prevail, parents, is that you show that you made a reasonable request and the school district could have reasonably come up with some type of accommodation. So they made it a reasonable basis test, which a lot of legal laws are based on reasonableness. Doesn't mean the parents win every case, but it does mean that they can prevail and pursue these claims without having to show venality on the part of the school district. The upshot is that this is going to open up a lot of avenues for parents with special needs students to be able to negotiate with school districts and say, hey, you know, our child needs this kind of service or that kind of service, and you really have to give it to them, and the school district's then will be required to negotiate with them to some extent, rather than just saying, no, we're not going to do it. The law does allow parents who prevail in these cases to get their attorney's fees. And attorney's fees in these cases are quite substantial. I had one case several years ago where it was $87,000 in legal fees to fight these cases. But because the parents can get legal fees if they win, school districts are now in a position where they're probably going to negotiate and compromise with the parents because of this rule. So this ruling really opens up the rights of parents and the obligations of school districts to go out of their way, if you will, to give special services to disabled students. It's a big decision that has national implications, for better or worse, but it certainly helps parents with specialized students. It impinges upon school districts and administrators who don't necessarily want to have to provide extra services to students, but that's what the case says. And it's a Minnesota case. I'm gonna just talk about this case real quickly. Shadow docket. I talked about the shadow docket. The shadow docket cases come up quickly. They're emergency decisions. Court hears a case. The lawyers file briefs within 1 day rather than 60 days, which is the usual rule. Court doesn't even hold hearings, court issues a decision, no reasoning. That's what they're doing. One of the examples, this was a very early case. Remember Elon Musk and Doge? It seems like it was decades ago, but in the early days of the Trump administration, when they were laying off all those people, well, one of the early cases, there've been a lot of other ones, but one of the early cases was brought on behalf of 16,000 of the terminated employees. They got into court real quickly. This was one of the cases. There were many others, but this typifies the way these cases have gone. And it reached the Supreme Court within a matter of days, back in February, or March actually, March. And the 16,000 employees who were let go in this Doge purge were suing. That's not all of them, but some of them. And the court said they were suing them, but their union brought the suit. Their union brought the suit on their behalf. It wasn't 16,000 separate suits. And the Supreme Court said they lack standing. A union can't bring a case like this on behalf of its members. And that kind of was, and that was one of these shadow rulings. That seemed to depart from about 150 years of jurisprudence. Because one of the reasons that unions exist, for better or worse, is to represent their employees, and it's very typical for unions to sue on behalf of their employees. Who else are they going to sue on behalf of? That's what they represent. Okay? I represent some unions, and I've been against unions, but the point is unions represent employees. That's what they, and one of the features that they have is the right to sue. Supreme Court said, no, you can't sue. They didn't rule in favor of Musk and Doge. They just said, why don't you start over again, why don't all 16,000 of you sue? That kind of takes a lot of the, that pulls the rug out from the unions and the employees, because it's pretty difficult for the employees to go through these lawsuits if the unions can't represent them and pay the fees. So this is an example of the Supreme Court really making it very, very difficult to fight these and layoff cases. We're seeing some of them. Yesterday, a court required, barred the president from removing the Federal Reserve Commissioner. That was just yesterday. That's an appellate court decision. That's going to reach the Supreme Court in a couple of hours, I think. And if you're betting on that, take the over on that. I think the Supreme Court may reverse that. So that's just my prediction. Don't hold me to it. Right? Hold me to it. But that's how these cases, that's how these employment cases have gone. Many of these cases, the lower courts have restricted the firings or the layoffs. And once one of those cases reach the Supreme Court, when they do, not all of them do, they get overturned and reversed in that might. In this example, I'm going to skip over this one, because I just don't have enough time. Here's two interesting cases here. This is a charter school case, very important case. Charter schools, as you know, were conceived and born here in Minnesota. Minnesota is ground zero for charter schools. Ember Reichgott, who Peggy knows, and I probably was, you were in the legislature with Ember. Ember Reichgott, represented senator from New Hope, Crystal area. She invented, to some extent, charter schools. And I won't get into all the details about that, but charter schools are public school districts. They're in the public school district. There's charter schools right out here in Golden Valley. I think Golden Valley has 3 charter schools. They're run by parents and teachers, but they're funded by the school district, public funds. Okay? And there's 189 charter schools in Minnesota. There's 8,000 in the country. They all were born here in Minnesota in 1992. This case was in Oklahoma. The Oklahoma Board of Education, the State Board of Education, an experimental program allowed a Catholic charter school run by the Catholic Church, which some of these schools are religiously oriented. Not just Catholics, there's some Muslim schools, there's some Jewish charter schools, but those are privately funded by donations from those parents or their religion. But in Oklahoma, they allowed public taxpayer funds, to pay the teachers for a Catholic school. That was challenged, the use of public funds, taxpayer funds, for a religious school. You wouldn't presumably see the teachers at Benil Fine School or De La Salle being paid by the state. But Oklahoma said they could do that. That case reached the Supreme Court, and many people, because of the way the Supreme Court has handled religious cases over the years, thought that the Supreme Court would uphold that. I did too. But a funny thing happened on the way to court. Judge Amy Coney Barrett recused herself. She removed herself because the lawyer who was representing the charter school was a friend of hers. They were fellow faculty members of the Notre Dame Law School, which she was a professor. So she removed herself. She said, I have a conflict of interest because I know this fellow. She probably didn't have to remove herself, just knowing the fact that she knows him. A lot of the judges know lawyers. But she removed herself. That left 8 judges, and they tied. John Roberts joined the 3 liberals. Justice Roberts joined the liberals became a 4-4 tie. In law, as in baseball, a tie goes to the runner, as they say in baseball. So because it's a tie, the lower court decision stands. The lower courts had ruled that arrangement was unconstitutional. So therefore, the tie vote goes to the lower court decision goes into effect, and the charter school was not able to get public funding and disbanded. Big decision. The religious groups that supported that were expecting that if the rule had been different, they would open up a lot of charter schools on public funds, a lot of religious charter schools on public funds. This was just an experiment. This was just a test case, but it didn't work for that case. But the issue is likely to return to court soon, because if another case comes through and she doesn't recuse herself, then she has a deciding vote as to whether charter schools can be paid with public funds. And if the rule is that it is, you're going to see, for better or worse, good or bad, you're going to see a lot of charter schools, a lot of religious organizations setting up their own charter schools and getting paid by the taxpayers, including tuition. Tuition will be paid by the public schools, and the faculty and staff will be paid by public funds. If that happens, don't know if that happens. Here's another Minnesota case that the court decided not to decide. This is a gun restriction case, big issue, of course. Minnesota is one of about 3 dozen states that has a law that bars licensing and possession of guns by underage people, under 21 years old. Most states have those laws. They vary a little bit as to whether they can get a license or whether they have to have possession, whether they can possess a gun or whether they can buy a gun. But the basic premise is that if you're under 21, you can't lawfully have a firearm. You can't buy one from a licensed dealer. There's other ways of getting them, but these laws are on the books. And both the trial court here in Minneapolis and the appellate court ruled that the Minnesota law was unconstitutional. Unconstitutional? What's wrong with that? Second Amendment, right to bear arms. Both courts said that an age restriction on ownership of guns. The court said, we don't know if it's a good idea or a bad idea. We're not in the idea business, but we do say that it violates the Second Amendment. So the Minnesota law was upheld. The ruling was upheld that Minnesota cannot bar under 21 years of age, and many other states have similar laws. Keith Ellison, the Attorney General, appealed that decision to the Supreme Court. He was joined by one of his natural allies, the NRA. The NRA and Ellison joined together. Why is that so? Ellison was appealing the case because he lost. The NRA was appealing the case because they wanted a nationwide ruling. There's different laws in different states. For instance, in Florida, the court had ruled that law was valid, a similar law. So states differ. So the NRA was hoping that by getting this case before the Supreme Court, they would have a nationwide ruling that would apply across the country that you can't bar under 21 from guns. Ellison was appealing it because he wanted a ruling to the contrary, you can bar 21-year-old. The Supreme Court punted and said, we're not going to decide the issue. So there's a crazy quote of number of laws. Some states bar underage purchasers or users of guns or possessors of guns, some don't. And that issue may come back before the Supreme Court or not. It had its chance, but it punted. It decided not to, even though both sides wanted the court to hear the case. They said, no, we're too busy. Oops, no. Help again. What did I do here? I do this again. I'm running out of time. I was pressed the wrong button. Thank you. Oh, okay. More gun cases. Don't have a lot of time to talk about it. This is a ghost gun case. This is a federal case upholding the federal law barring ghost guns. Ghost guns are homemade guns that people can make. They can get it right off the internet. They can make it in their basement. There's no serial numbers. There's no tracing. And there's no, you don't have to get it from a light. There's no background checks, like I'm going through to become a member of this organization. Nothing. Anybody can make a ghost gun. It is estimated there are 45,000 of these ghost guns floating around. I don't know how they estimate that because you make them in your basement. But they're a real problem and a real danger. They haven't been used in any of these mass shootings. These are generally handguns. So they're not mass shooting guns. But they've been used a lot in robberies, basic street crime, and stick-ups at liquor stores and stuff like that. Small crimes. Not small crimes, but smaller matters, not mass shootings. But the Supreme Court, in a rarity, the Supreme Court upheld the federal law banning ghost guns. That doesn't mean they're going to stop it. It means if you're caught with a ghost gun, you can be prosecuted for violating federal law. Now that, you know, you're not gonna go in someone's basement, but it's a law in the books that says you can't have ghost guns under federal law. What do I press here? That's what I did. So, no, so don't worry, there's not, at least the law bars ghost guns, except in Minnesota. Shortly after the Supreme Court decision on the federal law, there's a separate Minnesota law that's a little bit different, and that was challenged. And the Minnesota Supreme Court unanimously ruled that the Minnesota ghost gun law is unconstitutional because of its fuzzy, imprecise wording and language. So the Minnesota Supreme Court threw out the state ghost gun law, while the federal ghost gun law continues to exist. So go figure that one out, folks. Problem there. It's just one of the myriad of problems we have in gun issues. Incidentally, if anyone's interested in that, this morning in MintPost, there's an article in MintPost, mintpost.com. It's an online newspaper. Somebody familiar with it? I wrote an article that was published this morning about not these cases, but about some of my thoughts about the gun violence crisis and some of the issues that need to be resolved. And this is one of them. It's not in the article, but this is one of them. It just shows the complexities. You have federal law that says one thing, state law says something else, and state laws differ. And I think it's worth noting that because it's part of the problem we're facing right now. I'm gonna skip over the capital punishment cases. This is I got about 2 more minutes here. Reverse ruling. This is a reverse discrimination case. Ames versus Ohio Department of Youth. This is a woman, straight white woman, who was bypassed for a promotion. The promotion went to a gay man. She later, a year or so later, for other reasons, was reassigned and essentially demoted. Not for that reason, but just coincidentally, so they said, she happened to be given a demotion and someone else got her job. That was a gay man. She sued and said, I'm the subject of discrimination because I'm a white woman and they gave 2 jobs to gay people. And as a result of that, she sued, and the court said that she could sue for what's known as reverse discrimination, and they made it much easier to do so. And this was a unanimous ruling written by Justice Jackson, the most liberal member of the court. She said that in these kind of cases, if the claimant can show that there's a prima facie case, that means she can show that there was some degree of discrimination, and the employer can't disprove it. They put the burden of proof on the employer, you can win a reverse discrimination case. What that portends is a lot more reverse discrimination cases. This makes it much easier for white people, mainly white men, white women too, makes it much easier for white people, majority people, to sue if they're not given a job or lose a job or not hired or given a promotion in favor of a minority, racial minority, religious minority, affectional preference minority. It's a big case and it's going to change the way those employment decisions are made in a significant way. Skipping over a couple other cases here, I'll get to my final one here. This is the birthright citizenship case, and the birthright citizenship case arises under the 14th Amendment, which provides that any person born or naturalized in the United States is a citizen of the United States in the state in which they live. That's a Civil War amendment after the Civil War. It was basically directed to slavery, but it's been construed to allow anybody who's born in this country to be a citizen and be entitled to all the rights under the Constitution. It mainly applies these days to the children of undocumented immigrants, of which there are lots, several million. And the question is, do they have any rights because they were born here? President Trump, as you know, has campaigned, and he and his administration vigorously asserted that they don't have any rights because their parents weren't citizens. The Constitution says it doesn't talk about parents, it says it talks about the person who's born. But that's the issue in this case. It went to the Supreme Court, and the Supreme Court punted again. He said, we're not going to decide that case. They said, however, we got something else in our mind. In this case, the federal judge had enjoined the Trump birthright citizenship ban. And the Supreme Court said you can't do that on a nationwide basis. The court said from now on, with some exceptions, any of these challenges to Trump policies or Trump procedures, administration procedures, have to be done on an individual case-by-case basis. Just like the Doge case we saw earlier. The court is saying you can't have a nationwide class action that affects everybody. Each case has to be brought separately. That significantly impairs the ability to challenge these Trump regulations and rules, either for better or worse. I'm not saying it's a good idea or a bad idea, I'm just saying it is the law that the Supreme Court wants these cases to be brought individually, which significantly limits people's ability to challenge these cases as a group, a class action, and of course the cost of each of these cases is in the hundreds of thousands of dollars. One case may cost $300,000 to $400,000. 1,000 cases may cost $3 or $4 million. So it really affects the ability of people to pursue their rights in federal court. Trump just about won every case this year, 19 out of 20, as I said. He had a great year this year in terms of the Supreme Court. 19 out of 20 of the Supreme Court decisions have been favorable to the Trump position, whether you like it or not. He's almost won every case, not quite like the 1974 Miami Dolphins for you football fans, the perfect team, like 17-0, but pretty close. So he's that's his record, 19-1 this year. That'll get you a lot of championships in athletics. We'll see what happens as time goes on. Quick look at what's ahead. 2 minutes here. Quick look. Here's some of the cases that are coming up this year on this term that starts in October. There's more. The birthright citizenship. More litigation over birthright abortion. Abortion is back before the court. Campaign financing, religious rights. There's litigation involving the National Guard. All those issues are getting up to the Supreme Court now. The National Guard issues. The employee displacement cases, these are the Doge cases. There's still a couple dozen of these still going through the system. We'll see how those come out. There's two more transgender cases coming before the court as to whether states can be barred from allowing transgender students to participate in high school sports. Big issue, controversial issue, big issue last campaign. And same-sex marriage might be back before the court. There's a challenge to the Obergefell versus Hodges decision that was 10 years ago to allow same-sex marriage. The court has received a petition for another case to overturn Obergefell versus Hodges. 3 of the judges have indicated they're receptive to that. The others haven't said whether they are or not. The court has not agreed to hear that case yet, but it's on the docket for them to decide whether to hear the case. In the same-sex marriage case, that was a 5-4 decision. 3 of the judges who approved same-sex marriage back in 2015 are no longer on the court. Justice Ginsburg, Kennedy, who wrote the decision, and Breyer, who retired. So they've been replaced by Gorsuch, Coney Barrett, and Brett Kavanaugh. So there's a lot of people who think that the same-sex marriage ruling of 10 years ago might be in precarious position. Others say, nah, they scoff at it, they say, don't worry about it. There's no way a Supreme Court's going to reverse a constitutional right. And some people say, yeah, well, take a look at the Dow's case. So we'll see. It's going to be an interesting year, and we'll see what happens. And I think I've made it through now, have I not? Yes, I have. So, see you next year as a member.